This is the topic of my research, the implications of adopting the principle of informed consent in Sri Lankan medical malpractice law, a critical analysis in light of Montgomery versus Lanarkshire Health Board, which is a UK Supreme Court case. Now, this is the basic overview of the presentation I'm going to conduct today, and it won't discuss all the issues that I have discussed in my paper because of the lack of time. So these are the basic topics that I'll be discussing during this particular presentation. Now, before I get into the law relating to the topic, just let me give you a brief background as mainly to the social context. I'll get into the legal context later. The social context and the social attitudes in which this particular research was conducted and what is relevant. First let's look at the status of the medical profession. Now, ladies and gentlemen, we live in a society where the medical profession is an extremely respected profession and doctors are considered extremely knowledgeable people. And even if you look at our history, we usually go to the Vedarala in a particular village for different advice on different aspects, not just medical advice. So because of this, there is this preconceived notion that the doctor knows best in our society, and that we usually go along with whatever advice that the doctor gives. However, in recent times, this notion has been subjected to a lot of change. There is a change in this particular social paradigm, whereas people are starting to question or starting to reevaluate the advice given by doctors. One reason for this is because it is not just restricted to healthcare providers. It applies to all areas of our day-to-day lives where we all want the best service, the best product. And because of that, we always question. Now, if you go to a doctor and a doctor prescribes a certain medication, what we usually do is we question why are you prescribing this particular medication? Why can't you prescribe something else? I heard of this other brand that is also good. And what are the side effects of this medication? So people they are more inclined to ask questions from the doctor and question their decisions, and that is something that is coming up now. So another reason is that the reason for losing trust, faith in the medical profession is due to, if you just go through the newspapers and so on, there are increasing number of reports with regard to medical negligence, which is, for example, a doctor amputating the wrong leg, or those are severe cases. So because of that, and also how the medical profession is becoming more commercialized, and doctors have less time to spend with their patients, and because of that, the trust we have in the medical profession is going down. So because of this notion of doctor knows best is now changing, and because of that, these changes in social attitude are the major things that I'll be focusing on in this research. So my research problem is based on how this principle of informed consent, which I will describe later, will help address these changes in social attitude, how they can help raise the standards of healthcare and also the standards of the medical profession. And since I'll be focusing on this case primarily, I'll be talking about how the law in this particular, the judgment given, how relevant it is to Sri Lanka, because it's a UK judgment, and how relevant those principles, legal principles are in the Sri Lankan context. So these are the three primary research objectives I discussed in my paper. And during this presentation, I will be only addressing the second and the third objectives due to the lack of time. So I'll be focusing on how the principles expounded in Montgomery and how relevant they are to the Sri Lankan context. So next, let's look at the conceptual definitions. First, what is informed consent? Informed consent is essentially getting consent from a patient after the appropriate amount of information has been disclosed to that particular patient, and that allows the patient to make a voluntary choice. This is different from just signing a consent form or something that is just handed over to you by a doctor. You are first given the necessary information that you need to make a voluntary choice on your own. So it is the ability to make an informed decision that the principle of informed consent provides. And to look at how the lack of informed consent as grounds for delictual as a delictual remedy, how it differs from other forms of malpractice, which is what is commonly litigated in Sri Lanka, where, for example, other forms of malpractice include where the doctor has been negligent. As I mentioned earlier, if he has amputated the wrong leg or was negligent in carrying out a particular surgery, that protects the patient's right to competent health care. That is the patient right that is protected by other forms of negligence, which is commonly litigated in Sri Lanka. So the principle of informed consent, on the other hand, is where the doctor is litigious action is taken against the doctor because he failed to provide necessary information so that the patient was unable to avoid a particular treatment that caused harm to him. So basically, the lack of information or is what is usually litigated under the principle of informed consent. And I've gone into depth relating to the elements and the standard of disclosure in my paper, but due to time constraints, I won't be able to talk about it in depth. So let me get to the case. This case, Montgomery versus Lanarkshire Health Board, is a recent case, as you can see, 2015 case, and it's a landmark judgment. I'll get into the judgment later. But as for the facts, what happened was Mrs. Montgomery was a woman of very small stature, and she was suffering from diabetes mellitus. And because of this, there is a 9 to 10% risk of such pregnant mothers during delivery of the baby suffering shoulder dystocia. So shoulder dystocia is basically where the baby gets stuck in the vaginal passage or the birth canal. And this actually occurred, and the baby was deprived of oxygen for 12 minutes and and sustained brain damage and was diagnosed of cerebral palsy and Erb's palsy. So what happened in this particular case was that Mrs. Montgomery sued the doctor for failing to disclose that particular risk, that 10% risk, of not informing her of that 10% risk, and she said that if she had been informed of this risk, she would have opted for a cesarean section rather than a natural birth. So that is what the action was brought forward for. And the judgment was given in favor of the plaintiff. 5.25 million pounds was awarded in damages. And this was finally in the Supreme Court. It was a Scottish case which finally came to the Supreme Court. And what's important here from a legal perspective is this indicated a clear change, a deviation in English law from the prudent doctor's test to a prudent patient's test. So basically, prudent doctor's test, commonly known as the Bolam principle, which was introduced by the Bolam versus Kane Hospitals case, where they look at whether action can be taken against a doctor, and if the doctor can prove through expert medical testimony or through a peer professional or another doctor can accept that the defendant's action was not negligent and that it is acceptable in general medical practice, then the court cannot find that doctor liable, and it is looked at from a doctor's point of view. Whereas after this case, the law changed to a prudent patient's test, where it is the court looks at it from a reasonable patient's perspective and considers whether a reasonable patient would find that information given by the doctor sufficient to make an informed decision. So that was the legal change that was brought about by this particular case. And now moving on to the Sri Lankan context, the biggest problem that we have in the Sri Lankan context with regard to medical negligence is the lack of case law, because the reported judgments. And since it's law on dealing is governed by Roman Dutch law, it is restricted to common law principles. And in the past few decades, the reported case was the Arsukularatna case, Professor P. Anderson's Arsukularatna. And that did not address this issue of informed consent as well. And there are several academics who have commented on this, and for example, Ms. Ulupadi Liyanage from the University of Colombo, who wrote an article on this, and she also states that the principle of informed consent is not clearly a part of Sri Lankan law. So, but however, in practice, we are in certain hospitals, especially private hospitals, we are given consent forms, and we are required to sign it before accepting a particular form of treatment. But there is a difference between merely signing a consent form and actually having informed consent, actually having information necessary to make an informed decision. So getting into the most important part of my presentation, the judgment in Montgomery versus the issues in Sri Lankan context. So the first I've broken this down into several subtopics, the doctor-patient gap. Now this is basically where you can identify that there's a knowledge and as well as a communication gap between doctors and patients. Sometimes a patient might not be able to understand the medical jargon that a doctor relates. So this cartoon, for example, states that the doctor is saying you suffered a contusion of the soft tissue below the thoracic vertebra, exacerbating the proximal sternum. So if any of us hears this, we will be completely lost. But the simple translation of this is that you have a bruised rib. So basically, if a doctor takes the time to explain a certain procedure or a certain medication in simple terms, that is something that the doctor can actually do and help bridge this knowledge gap. And the other cartoon talks about how what we actually say to the doctor and what the doctor is actually interested in are two completely different things. So that also creates a gap between the doctor and the patient. And how the court in Montgomery addressed this first, they said that doctors need to look at patients as persons holding rights, and they are consumers exercising choices. So because of this, we cannot just look at patients as just passive recipients of the doctor's healthcare. So we have to look at the patients as persons exercising choices, as consumers exercising choices. And it is wrong, it is a mistake to assume that patients are uninformed. So that is something that is changing in the current society and something that the law should also address. And now moving on to the doctor knows best principle. Now this is one of the major arguments against this principle of informed consent, where most doctors assume that the patients will be okay with most treatment that they prescribe. So because of that, they don't go into the nitty-gritties of a particular treatment or a particular treatment procedure. So the importance here is the court noted two exemptions. So a doctor isn't required, legally obligated to disclose information if the patient insists that that particular disclosure is not necessary. If the patient says, okay, I'll go along with whatever decision that you want and I'll follow any treatment procedure you recommend, then it is not necessary for the doctor to disclose that information. And also, if the doctor feels that the patient is not competent enough, or if there's a risk to the patient's life in disclosing this information, then the doctor can invoke this thing called therapeutic privilege, where the doctor can refrain from disclosing certain information, and those are the two exceptions that was issued by the court. Now, the difference here is we have to understand what is the norm and what is the exception. Should disclosing be the norm or non-disclosure be the norm? So what I propose is that disclosure should be the norm, and unless a patient specifically tells the doctor, I don't want to be told about all the nitty-gritties of this particular procedure, unless the patient says so, or unless there is harm to the patient's life, the doctor should be inclined to disclose this particular information. And also, time constraints, I'm also facing some time constraints now. So, as this cartoon says, the doctor will see you now, but I can't promise you to talk to you, he will definitely see you. So, the problem in Sri Lanka also, especially when it comes to urban areas and private channeling centers where doctors see more than 100 patients a day, time becomes an issue. But the UK court in Montgomery said that under the GMC, the General Medical Council Code of Ethics, there is already an obligation to pay attention to the patient and to give the relevant attention during examination, and that is there in our SLMA Code of Ethics as well. And imposing a legal obligation is not too excessive. So, as to the other two arguments, the defensive medicine argument and the floodgate argument, yes, I'm sorry, sir. Yeah, I'll wrap up. So basically, in conclusion, what I'm saying is that this principle of informed consent will actually help protect patient autonomy, because it will give us the opportunity to make an informed decision regarding what is happening to us and what is happening to a patient's own body. So by doing that, that will increase the accountability and also increase healthcare standards. So thank you very much.